Hello to everybody. My name is Thomas Steyert. I'm working for an executive agency established by the European Commission to support the activities of the Enterprise Europe Network. And I welcome you to today's edition of our Embracing Global Markets webinar series. For the few of you who have not yet heard about the Enterprise Europe Network, I would like to spend a few words on what we are doing. We are de facto the world's largest business support provider for growth-oriented small and medium-sized enterprises and startups. Some 500 organizations in Europe and beyond European borders are working for us, and well over 3,000 business advisors are actually providing services to European companies and international companies. To give you a much better idea about our service portfolio, I have prepared this overview for you. So we are providing services related to internationalization, innovation, business, technology, and research and development, partnering, sustainability, EU single market, access to finance, and access to EU funding. In addition, we offer resilience support and digitalization services, so helping companies to adopt digital solutions to enhance their business needs. So in a nutshell, we are offering all the help and the support growth-oriented companies need to enter a new market via providing market intelligence. We're helping companies also to enhance their innovation management capacity. We help them to find business partners for commercial purposes, but also to engage in technology cooperation and to find partners cross-border to engage in research and development cooperation. We advise companies to adopt more sustainable business models, and we make sense of the rules and industrial regulations related to the EU single market. So that's in a nutshell our service portfolio. If you think your business could benefit from such services, don't hesitate reaching out to us via our official Enterprise Europe Network website, and there we have a list of our official contact points in all European countries, but also in quite a huge number of countries on other continents. Now I would like to move on to today's edition, to today's webinar, Doing Business in the United States, all you need to know about US business immigration rules. So in a nutshell, what you will learn today is what paperwork you need to get right in order to work and live in the US, and what tax implications this will have. If you have any questions for our experts, drop them in the chat section on YouTube or on WebEx, and our experts will answer them during the webinar. But now I would like to give the floor to Erin, the CEO and President of the European American Chamber of Commerce in Texas, who will be leading us through today's webinar. Erin, the floor is yours, and good luck for the webinar.
Wonderful. Thank you, Thomas. Good morning or afternoon, everyone, and welcome to today's webinar on navigating U.S. immigration rules and strategies, hosted in collaboration with the Enterprise Europe Network and the European American Chamber of Commerce, Texas. I'm Erin McKelvey, President and CEO of the EACC Texas, and I'll be your moderator today. We are thrilled to have a panel of talented speakers with us today, each an expert in their own field, to help guide us through, pardon me, the complexities of entering the U.S. market and establishing long-term residency. Before we dive in, I'd like to briefly introduce our speakers. Debrina Houston is the managing partner of Houston Law Firm PLLC, where she specializes in employment-based immigration, representing foreign investors, entrepreneurs, and individuals of extraordinary ability. James Garilas is a business immigration attorney with Ogletree Deakins, working with businesses of all sizes to develop tailored immigration strategies. And Guy Vascari is a senior wealth planner with HSBC Private Banking, specializing in tax planning, estate planning, and pre-immigration tax strategies for high net worth individuals and clients. Let's talk about one of the first steps when moving a business or key personnel to the United States. Debrina, if you wouldn't mind, for companies or individuals planning to move to the US, what factors should they consider when determining the right visa?
Thank you, Erin. So I'm just gonna cover, I guess, some of the most important factors for businesses trying to move to the United States. First one is business activities in the United States. So you have to determine whether you plan to establish a new office, expand an existing branch, or enter into partnerships. And depends on which one, what is your the business activities that you plan, then you will, that will depend on what type of visa you're gonna get. The next one is ownership and investment. So if you're investing a substantial amount of capital into the United States, perhaps an E2 investor visa might be a good fit, or even a EB5 immigrant visa or a green card. So depending on what you want to invest, how much you want to invest, in your long-term plans.
Hold on one second. Is it me, or am I the only one seeing half of Debrina's screen? There we go. Thank you.
Okay.
Much better that way.
Thank you. Also, role of key personnel. Are you going to transfer your executives? Are you going to hire local talent here in the United States? Do you have people of extraordinary ability that you want to transfer from Europe to the United States? All of these are important key consideration before making the move. And last but not least, duration of stay. So are you planning to move permanently? What is the long-term goal? Are you gonna apply for a permanent residence later on, or is it just something temporary, that just want to do business in the United States? And I guess last but not least, there's so many, but also compliance with immigration laws. So you have to ensure that your business model aligns with U.S. immigration laws and that you comply with employment and labor regulations and tax, of course, when hiring U.S. workers. So I would look into these factors, before even considering moving to the United States.
I think that was part of my next question. When in their project timeline should individuals or companies begin preparing for the immigration process? And how much time should they typically expect for the procedures to be completed? This will help our attendees get a clearer understanding of kind of the steps involved in the overall process.
Yeah, so the earlier the better, given given the backlogs that we're currently experiencing, given the complexity of some of these visas. So generally speaking, in terms of time, I mean it's different for everybody, but I want to say minimum 6 to 12 months in advance, just to make sure that everything aligns and you have enough time for potential delay, potential backlog with the Department of State or here with immigration services. So the earlier you start the planning, the better.
Sure, that makes sense. James, James, what challenges do companies often face with visas like the H1B and L1, and what advice do you have for avoiding these obstacles? Have we got James?
Yeah,
he's on mute.
He's muted.
Sorry about that. Thank you. So H1B and L1 are two of the most common visa categories that we typically see. And each of these visa categories have its own sets of pros and cons. Just for general background, the H1B is really one of the most popular visa categories in the US, and it's a vital tool for US companies to hire and retain highly skilled labor. The H1B requires an individual to be employed in what's called a specialty occupation. And that's an occupation in which the foreign worker must either require a bachelor's degree or higher, or its equivalent in a specific field to be qualified for the position. Common examples of a specialty occupation for H1B purposes would be software developers, engineers, or data analysts. And a challenge for the H-1B is that it is a temporary non-immigrant visa. It is initially granted for up to 3 years, and then you can get H-1B extensions after that for up to a statutory maximum of 6 years. Now, we do have some exceptions that allow individuals who have met certain milestones in the US-based green card process to exceed the 6 years of statutory H-1B time. So that's why it's important for individuals who are here in the US on a temporary non-immigrant visa to carefully consider their long-term goals with their employer to determine if they are going to stay in the US, potentially looking for permanent residency or for a longer period of time, so that certain milestones may be checked off in advance so that individuals can exceed that typical 6-year maximum of H-1B time. The most significant pitfall and disadvantage to the H-1B visa is that initial H-1B applicants, individuals who have not previously held H-1B visas before, are subject to the annual H-1B lottery. The H-1B lottery only occurs once per year. It's in March of each year. And upon individuals who successfully win that lottery, those individuals do not get work authorization in the US pursuant to the H-1B until the following October, on October 1st, when the new government fiscal year starts. With regard to the H-1B lottery, the way the US immigration system is currently set up, there's a maximum of 65,000 H-1Bs available under the regular cap, and then another 20,000 H-1Bs available via the master's cap, which is eligible only for foreign workers who have obtained at least a US master's degree or higher. They are eligible for that second master's cap as well. So in total, you're looking at approximately 85,000 H-1B visas each year. And as you may have guessed, the demand significantly outweighs the supply. That's where the lottery aspect comes into it. And right now, based on the past few lotteries that we've seen, the odds of winning the lottery and securing an H-1B visa through that lottery process is probably around 25 to 30%. Again, so the H-1B category is great. It offers a lot of flexibility because you can take your H-1B from one H-1B employer to another. However, the downside is that it is difficult to obtain because you have to go through that initial H-1B lottery process to attain that H-1B visa. On the L1 visa side, L1s are critical tools for multinational companies seeking to transfer executives, managers, and those with specialized knowledge into the US. The L1 comes in two different forms. We have L1As, which are eligible for managers and executives to be transferred to the US. And then we have L1B visas, which are for those individuals who have specialized knowledge in a particular proprietary or company-specific tool, technology, or process that the US entity needs to bring over. The critical limitation for the L1 visa is that the two entities, both the foreign entity where the employee currently works and the US-based entity where the foreign employee would like to be transferred, must be qualifying companies. They must have a qualifying relationship. Typically, we see that as a parent, subsidiary, or affiliate relationship. And critically, the sponsored foreign worker must have worked for that foreign parent, subsidiary, or affiliate for at least 1 year in the previous 3 years prior to the transfer. With regard to limitations on years for the L1 visa, again, it is a temporary non-immigrant visa. Initially, it is issued for up to 3 years, and then the L1B has a maximum of 5 years, and the L1A for managers and executives has a maximum of 7 years. One critical note here is, unlike the H1B visa, there is no option to exceed that maximum period of stay for L1A and L1B visa holders. Thus, it is even more critical for those individuals to start the green card process and permanent residency process as quickly as possible if that is a long-term goal for those individuals. A successful L1A visa case for a manager or executive will be able to show clear evidence of managerial authority, including hiring, firing, performance reviews, and delegation of authority to show that this individual is a true manager and not just the worker bee who is performing the day-to-day tasks. For a successful L1B case, it's critical to show that this specific proprietary or company-specific knowledge or expertise lacks in the US labor market. And the only way for our company to be successful is to bring this critical L1B specialized knowledge worker over to the US to bring this knowledge information and skills to the US. So those are really the two critical visa categories that we see most often with regard to work visas. However, aside from true work visas, we also often see the B1 business visitor category. The B1
Okay.
business visitor category allows individuals to enter the US to perform specific business activities, such as attending business meetings, negotiating contracts, participating in short-term training, or attending a conference. Now, it is critical to note that the B1 business visitor visa, again, does not allow somebody to perform active work in the US and does not allow individuals to render services in the US. Somebody who does, enter the US in a B1 business visitor category, but actually performs labor or renders services in the US would violate the terms and conditions of their visa.
Let me
I
jump
really
in
want
there
to stress
real
to you
quickly.
all that, oh, I'm sorry.
That's okay. I just wanted to jump in there real quickly because to me, the question is always, all right, so my company wants to see if we can make some sales in the United States, if our products are viable, we want to go to some trade shows, we need to be there with other people, we need to start showing our products. And there's, 3 trade shows in the United States, maybe within 2 months of each other, or maybe 5 trade shows in a year. Is it okay for companies to come in on, say, just a tourist visa to go to trade shows, or do they need to get a specific type of visa?
Yeah, for entering the US for trade show purposes, the B1 business visitor category is the appropriate category. That allows you to attend conferences, attend meetings, and these trade shows. The key issue there is to ensure that you do not overstay your visa once you enter the US, and B, to ensure that you don't actually render services or perform work in the US. If you were to either overstay your visa or violate the terms and conditions by working on a non-work visa, you could accrue unlawful presence. And if you do accrue unlawful presence, then the key criteria there is to look at how long did you overstay, how long did you violate the terms and conditions of your employment, because the US immigration laws impose serious consequences for overstaying visas or violating the terms and conditions of the visa. You would be, if you accrue over 180 days, but less than 1 year of unlawful presence, that's a 3-year bar from re-entering the US. If you accrue 1 year or more of unlawful presence, then you would face a 10-year bar from re-entering the US.
Wow. And I think a lot of companies really don't understand how strict and important that is. So let me go on to the next question. What visa options should companies consider for family members?
So the good news is that both the L1 and H1B visas that we've discussed, both of them allow dependent family members, including a spouse and children, to accompany the sponsored worker to the US. For L1 workers, their spouse actually is also eligible for immediate work authorization incident to entering the US in L2 status. The L2 visa holder does not have to actually apply for a work permit. Instead, they can use their I-94 record that shows they've entered the US in L2 status to work in the US. On the H1B side, their dependents also can enter the US in H4 status for both spouse and children. The downside to the H4 visa is that it does not allow the spouse immediate work authorization. There is work authorization down the line for H4 visa holders, but that requires the H1B worker to have hit certain milestones in the green card process. Namely, they must have an approved I-140, and then the H4 spouse is eligible to apply for work authorization. So if somebody enters the US in H1B status and they have an H4 spouse who will accompany them, they should probably anticipate at least 2 years before their spouse would be eligible to have work authorization in the US.
All right. Thank you for that. That was a great explanation. While on the subject of preparation, Give, how to prepare your finances for the big move to the other side of the Atlantic. Becoming a U.S. tax resident brings a lot of implications. What are some of the rules and tax consequences that individuals need to be aware of?
No, absolutely. I think it's important to sort of set the forest from the trees before you start the conversation, because I think it's important just to let people know that as long as they start their planning before they become a U.S. tax resident, you can really work magic, right? There's a lot of things you can do with minimal friction that'll sort of make your journey a lot more efficient, a lot more effective in terms of coming in, whether that stay is sort of temporary or permanent. But they do need to be keeping in mind that they are moving to a system from wherever they were in their home country to a system where U.S. will tax you on your worldwide income, regardless of source, regardless of where you are, if you are a U.S. income tax resident. On top of that, depending on whether your stay is sort of temporary, indefinite, or sort of permanent and indefinite, you're going to be subject to the U.S. estate tax in one of two ways, right? So the people who are sort of here on sort of temporary stay, where they have a definite present intention to leave, they're going to be taxed on their U.S. side of assets to the extent those assets exceed $60,000 at a rates of up to 40%, depending on the value of these U.S. side of assets. For those who are sort of staying more permanently or at least indefinitely, they might be considered domiciled in the U.S. and sort of subject to the U.S. estate tax on their worldwide assets, although they get a bigger exemption for being domiciled here, which is currently about approximately 13.6. Although at the end of 2025, it's inflation adjusted every year, it's going to get cut in half from wherever it is, so plus or minus 7, depending on where inflation goes in the next year and a half. Things to keep in mind is that there are simple steps you can take before you arrive that will make that journey much more efficient, much more effective. A lot of people don't realize that there's no sort of landed basis in assets when you come here. Some people tend to think that, oh, I'll get here, and if my portfolio is valued at $3 million, right, it's only the increase in value over that 3 million that gets taxed. No, that's not how it works. You sort of carry over your cost basis when you come to the States. So if you have a, zero basis portfolio that's worth $3 million and you start making sales, those sales are going to be taxed in the States, regardless of the fact that you weren't sort of in the US when you were sort of accruing that value or increasing those investments. Same thing with, real estate, business interests, all kind of assets like that, right? It tends to just carry over without any kind of increase in basis, simply by virtue of the fact that you came to the US and became a US person. Now, there are a lot of ways to sort of fix that, ways where you can sort of manually step up the basis in the assets or make certain sort of tax elections, which engage in sort of like a fiction of sort of stepping up the basis of the assets, which are fine with the IRS, typically referred to as like check the box elections for like companies which might hold the assets, financial or business or otherwise. It's, I don't want to, throw too much in terms of the technical stuff at people, but the important thing to know is that if you engage in these processes before you become a US person, you can take these steps to sort of manually step up the basis of the assets and therefore not sort of bring them into the US tax web. The other two things to think about is if you are worried about the US estate tax, maybe structuring your affairs so that either the temporary or the permanent worker is sort of not sort of worried about the US side of assets or their total assets, and also restructuring certain types of assets which might not be suitable for US persons, right? So there are certain types of financial investments which aren't suitable for US persons and get taxed at a very adverse way in the US. And there's also certain ways that you might hold business or other passive financial assets such as real estate, which are not necessarily efficient if you are a US income tax resident at that time. And it's important that you engage with a tax attorney to think ahead and say, okay, they can go through the process, they can help you rebuild and restructure everything in a way that's much more efficient.
So it sounds like a lot of work, but very doable.
Right. A lot of work, but it typically ends up in easy ways to fix it, right? So that's what I always tell. The US tax laws are very complicated. The solutions tend to be a lot more simpler. So as long as they keep the forest from the trees, they'll be fine. They just need to understand that they go in, okay, we'll do X, Y, and Z. This makes sense. It'll do these benefits for me. And that's really what they should be focusing on.
Okay, that sounds great. I think we covered this next one. As businesses and individuals settle in the U.S., ensuring long-term residency and compliance with immigration laws is crucial. So how to ensure that your immigration journey is smooth and legally sound? James, is there a first step, second step, third step?
Yeah, absolutely. So two main things we want to ensure a smooth and legally sound immigration journey. One is always pay attention to the small details. And that is when there are certain changes in your employment in the US, you may think that, a change in job title or a change in some job duties, or maybe even changing worksite locations, you may think it's not a big deal because you're still working for the same employer.
Okay.
However, US immigration laws are rather strict. So anytime there's a proposed change in job title, job duties, worksite location, or even salary, we want to be sure that you communicate those things to the employer's legal counsel so that we can review those items to determine whether an H1B or L1 amendment would be necessary. In some cases, an amendment is not necessary and the change is fine. However, we've often seen people run afoul with immigration laws because they assumed that a change was minor and it didn't impact their visa status. However, that minor change was not so minor in the eyes of the U.S. Immigration Service. And secondly, the other thing I would note is if long-term permanent residency is your goal, I always encourage individuals to get started on that sooner rather than later, because the maximum periods of stay for your visa category will sneak up on you faster than expected due to the long backlogs for U.S. permanent residency. So I would just encourage everybody, if that is a goal of yours, please communicate that to the sponsoring employer as quickly as possible so that we can all strategize to be on the same page to get these processes done as quickly as possible.
Yeah, it sounds like, you come over to the United States with your employer and you think you're doing great and you're working really hard and you get a promotion and you get a raise and your life is wonderful and you forget to talk about it. I'm sure
Right.
that happens quite often.
Yeah, it really, people get caught up in everything that's going well and forget that these work visas are particularly tailored to certain positions. A lot of them are job specific, and when you do change positions to a new role, sometimes amendments are required.
Yeah, great. Thank you, guys. And now back to Give. Could you explain the tax implications of the covered expatriate rules for long-term green card holders and those who become U.S. citizens? What should they be aware of?
Right. No, absolutely. I think it just goes back to a conversation of like how you come in matters, right? So people who come in on non-immigrant visas, they're not subject to a certain set of rules that might come in for people who decide to pursue a green card or ultimately go for citizenship. And the issue is that people who either become citizens and then try to relinquish their citizenship, or who are long-term green card holders, right, holding that for passing 8 calendar years as the green card holders, they could be subject to covered expatriate rules as they leave. So if they meet certain income or asset or tax liability thresholds, what'll happen is as they try to give up that green card or give up their citizenship, they could be subject to essentially a mark-to-market election on their assets as they're walking out. So they get a certain exemption of assets that they can sort of mark to market for free, but everything in excess of that is going to be subject to taxes if they're sort of walking out and selling and repurchasing their assets. Certain other assets, like certain types of interest in trusts or retirement plans, also might be subject to special rules as well. In addition to that, if you came in here and you had kids in the U.S. and your kids are now U.S. citizens and they might not be giving it up, covered expatriates also have much more difficulty sort of passing their assets either by gift or by bequest when they pass away to these sort of U.S. person beneficiaries. So it is something else to consider. So if saying I'm going to leave, I'm going to give up my green card, but my kids were born in the States, they're citizens and they're planning on keeping it, it's good to plan in advance of your exit to make sure that you're sort of mitigating or minimizing the impact of that, right? Because these rules can be pretty draconian depending on the circumstances. And in mind, right? So if you're going for the green card, just keep in mind that you have this sort of issue that might pop up if you hold the green card over a certain number of years or you decide to go for citizenship, and just be mindful of that and the consequences and make sure you're having that discussion with your advisors.
Yeah, I'm going to jump over to Debrina and ask if, what are some of the things that you see most commonly? I think there's some things here that we haven't covered yet, but what about your children or students who are coming to the United States and maybe want to go to college here? Can you touch on that real quickly?
Yeah, so for example, if you come on a E2, which is the investor visa, and we do, I mean, at least I work with a lot of companies that's the vehicle they utilize to come to the US. Once your child hits 21, they're out of the E2 status. So at that point, either they have to switch to F1, which is student status, through the university, or basically, or find something else, or leave the United States. So it's very important to to have these considerations before you come to the U.S., especially if the children are maxing out up to 21. The other thing that I have seen, and just a small example as to how the wrong visa and activities can impact you rather quickly. I had a client a couple years ago from the UK. They came, they opened the company. I wasn't involved at the time. And it was a company from the UK. So the CEO came, opened the company, hired a few people here. He came on ESTA. And then he kept coming, in and out multiple times throughout the year, and ultimately he got stopped by CBP, Custom and Border Protection officers, and they said, "Look, I mean, you need to get the right visa. This is not the appropriate vehicle for you to be in the United States and conduct business." So they didn't let him in, and then they sent him back. And then he started looking for what were his options, and then ultimately we did the E2, the investor visa. So things like that, that's why in the beginning I said you have to start planning pretty early, align yourself with the right professionals, the right resources, in order to avoid uncomfortable situations.
I'm sure that can be very uncomfortable, and it happens a lot. People really don't realize, as I said earlier, how strict it can be. I mean, the United States is a big place. People think they can come in during, different places, or just for this or a few months or something, but they really will come after you, and it's better just to avoid that if you can, for sure. Let's see, one last topic. Well, we've still got a little bit of time here. Let's go back to Give. Did we cover what types of investments should U.S. tax residents avoid, particularly foreign mutual funds or other passive foreign investment companies?
No, absolutely. We can touch on that briefly. It's just another aspect of things that people need to be mindful of, right? Because at the end of the day, there are certain types of financial investments common to other sort of non-US persons, non-residents. And as they come in, they might not be sort of immediately aware that those types of investments are sort of taxed in adverse ways in the US, because the US doesn't like those types of investments. Typically, the most common thing is like foreign pooled investment vehicles, like foreign mutual funds, foreign ETFs, UCITS, things like that. And the issue is these are called passive foreign investment companies in the US, or PFICs, right? And the issue is, unless certain elections are made to sort of mitigate the tax consequences, the tax consequences can be adverse if you hold these for a long time and ultimately sell them or get dividends from them at certain intervals. It's important to think of just more or less, obviously, talk to your advisor and get that done. But generally speaking, it's just foreign pooled investment vehicles, right? And so you can go invest in like, Petrobras or Vale or other like Brazilian companies, and that's fine if you're investing directly. But if you buy like an Irish ETF that goes and invests in, Brazilian energy and mining stocks, that's bad. It's the fact that it's sort of the pooled investment vehicle going to invest in those. And that's more or less it, right? You just need to be mindful of the fact that your investment portfolio might need to be slightly retooled. It's something you can talk about with your advisors, and they can make sure that sort of everything lines up correctly.
That makes sense, and I'm sure a lot of people don't consider those implications when even starting this process. Let's see, one last topic before we wrap up, and this is something that's really interesting. What are the implications of accidental citizenship, and what steps can people take to address this issue? We'll start with you, Give, again.
Okay. No, absolutely. It is one of those things that people might not be aware of, because the U.S. sort of gives you sort of citizenship by birth, by sort of physically being in the U.S. And I tell a story, like I had a client who lived in the Bahamas. Thought he was a complete non-resident. We're having these conversations in that sense and everything else. And then all of a sudden he's like, "Oh yeah, funny story. When I was being born, we had some complications. The Bahamas hospital wasn't equipped to deal with them, so they flew me to Jackson in Miami, and I was born there. And then I flew back to the Bahamas." I was like, oh, congratulations, you're a U.S. citizen. Like this is, and it just kind of like, their jaw drops, their eyes get wide, and they're kind of like explaining to them like, oh, by the way, you're been subject to U.S. income tax on a worldwide basis your entire life. Oh, by the way, you've got this issue with the U.S. estate tax and everything else, and people don't necessarily understand sort of the consequence of that. Just simply by being born in the U.S., you have all these tax consequences that sort of attach to you wherever you go, even if you never lived in the U.S. At all in your life. And there are ways to fix it, whether you want to keep the U.S. citizenship or whether you want to try to give it up, first sort of cleaning up your situation and then sort of expatriating. But it is important to sort of recognize that if you were in that situation, people in that situation, that there are sort of heavy tax consequences that sort of attach to that. And I guess I'll turn over to the immigration attorneys. It's just my little spiel on the tax side of things.
Yeah, James, do you have anything you'd like to add as we've been going along here pretty quickly. So I want to let James step in and see if there's something that we haven't covered that you'd like to go back over.
Yeah, no, just final thoughts from me would be that, there are a lot of visa options available in the US. There are a lot of ways to obtain permanent residency in the US, and multiple viable strategies could exist for each person. It's very important to thoroughly discuss and understand what your goals are, both in the short and long term, and have active communications with the US-based employer as well as their legal counsel so that we can tailor an appropriate strategy specifically for your case. Again, I understand the easiness in which it is to discuss your case with your friend's case, with your cousin's case. And while they all may have some similar qualities and some similar aspects, oftentimes it is hard to find two cases that are truly identical. So don't think that you are limited by what somebody else at your company has gone through or what a friend or relative has previously done. Oftentimes we can be strategic and creative and come up with a unique strategy for your case, which may be best given your personal circumstances.
Sure, that makes sense. I'm sure everyone listens to their friends or business associate who has gone through something and had a horror story, and they think, oh, it's never going to work for me. Debrina, do you have any great examples of how these things can be different for different people, and what your thoughts are on that?
Yeah, so kind of to go on the opposite what Gio said, there sometimes there are people who think that they're US citizen, but then it turns out later on the hard way that they're actually not. So sometimes they live their whole life thinking that they're US citizen. Maybe they even have a US passport, and then they apply for renewal of that passport. And then now, since everything is digitalized, the Department of State has all the records. It turns out that they're not U.S. citizen. So these are some. This happens.
So how did they get a
especially
passport in the first place?
My guess is back in the day, since nothing was digitalized, everything was paper, all the records are messed up. There was no fingerprinting. People, they had a birth certificate of some sort, and then they became a US. They thought that they're U.S. citizen. Now things have changed, evolved, improved, and ultimately, the government has more access to records and facial recognition, fingerprinting, and whatnot. These are cases more common, the border, with Mexico and to some extent Canada. But just FYI, these things also happen. In terms of advice, I guess, as I said at the beginning, start planning early. Make sure that you plan for contingencies. As James said, don't compare your case to your friends and cousins and whatnot, because it's not the same case, it's not the same facts. And align yourself with the right resources for you and the right professionals that will get you to the end of this journey.
Okay, so what happens if someone's visa is denied? Is that it? Can they start over?
Well, it depends, depends, what type of visa, depends why the visa was denied. You can always reapply for a visa. That's not, the US government, will take your application fee. But if your visa is denied, obviously you have to have a very serious conversation with your counsel or whoever is involved in preparing your documents as to any activities of the United States that you had prior, maybe to some criminal history. Oh, that's another thing that I wanted to mention. Once come to the US on non-immigrant visa, you kind of have to follow the law and don't
Good
go
idea.
into I call them extracurricular activities, things like, at least what I see, things like drinking and driving, just because in your home country that's okay, or there's no consequences, that doesn't apply to the US, and it actually has very serious consequences. So things like that you have to share with your counsel and see whether that's one of the reasons why the visa was denied. So obviously, if it's a government error, you can always apply, you can appeal, depends on what it is. But visa denial is not the end of the process or the end of the road.
Okay. And what about costs associated with the visa process?
So that's a tough question. So the cost
It
is usually,
is.
so you're always gonna have some sort of government fee or application fee, and that depends on the type of visa you're gonna apply for. On top of that, obviously, if you're working with a counsel, you will you will pay attorney fees as well. So how much are these fees? That depends on the type of visa you're going to apply for, the complexities involved in your process, and obviously the law firm that that will help you with. Everybody has sort of different fee structures, different fees, but that's all. You always gonna have the application fee, the government fee, and the attorney fee. Obviously you have to account also for like contingencies, complications during the process, and that's why it's very hard to tell you, yes, it's gonna be $1,000 or whatever.
Yeah, I'm sure. I'm sure. And if my visa is expiring soon, do I have to start over the whole entire process from the beginning?
Is that for me or James?
Actually, it could be for James. That'd be great.
Sure. Yeah, most visas are eligible for extensions up to the maximum stays. For example, as we spoke on earlier, H1B and L1 visas are issued for an initial up to 3-year term, and then they have 5, 6, or 7 years, depending on the visa category, for a maximum stay. You want to get working on the visa extension probably 8 to 9 months in advance, and you can file those extensions up to 180 days in advance, so 6 months before expiration. We do urge people to file as early as possible for many different reasons. One is a lot of states in the United States do not allow you to extend your driver's license unless you have a new approved visa. So oftentimes we run into situations where if somebody has not filed the extension early enough, they are getting close to losing their ability to drive in the U.S. So there are things that happen in the background that are unrelated to your visa and your work authorization that we must always be thinking of and trying to be proactive to ensure that we keep everything as smooth as possible for your immigration journey.
And will it take as long to the renewal process? Will it take as long as the original process?
It's unlikely to take as long because when you're starting new, for example, the H1B, you have to go through the lottery process. Once you've gone through the lottery, you've been issued an H1B visa status. You don't have to go through the lottery again. Similarly, for a new L1, you have to get the approval and then go to the U.S. consulate, get your visa stamped, and then re-enter the U.S. Once you have these visa statuses, you can apply directly with the U.S. Immigration Service for an extension, and you do not have to go through the consular process of going back and getting a new visa before your actual status is extended. So there are two different things we're looking at. One is your actual visa status in the US, and the other is the actual visa stamp in your passport. One is used for travel. The other is used to show that you have a lawful presence and work authorization in the US.
Okay. And Guy, do you have any last words?
Um, no, in terms of the last words, I think it's just reiterate kind of what we said in the beginning, right? In the sense that, at least from the US tax side, a lot of the rules are complicated, sometimes ridiculously overcomplicated, but they always boil down or typically boil down to simpler solutions, right? And so if you're talking with your attorney on that, you can say, okay, if you do this, this, and this, you get this, this, and that benefit. And you just wait and say, okay, this makes sense. This is worth it for what I get. The important thing is, as they were talking about earlier, is just go to your attorney, right? Make sure that you're doing this from the beginning and make sure you're doing it right. Don't rely on stories from friends as
Okay, I think we just lost him for a moment. All right. So is everybody else on? There we go. There's James.
Yep, we're here.
Okay, fantastic. Guess he'll be back in a second. So
I'm back, and I think I froze here for a sec. Sorry.
Perfect. So I guess we have a few minutes to take a few questions, and I'm not seeing the chat. Did we have any questions today? Can someone let me know? If anyone would like to add questions into the chat, go ahead and do that. Let me pull that up. All right. All right, so here's a question from Anurag Mittal. Are there any procurement business opportunities websites on which Estonian-based businesses can apply? Can anyone answer that? I'm not sure how that works for a specific country. Since we're in the United States, we're probably not terribly familiar with that, I'm sorry to say. See if there's. Oh yeah, I think that was as Gladys says, I think that was an EEN question. Here's another one. How long can someone be over on a visa to set up the company in the US while still getting paid from their foreign company? That's a great question, Adam. Who would like to take that? James?
Yeah, sure. So if they're coming over on an L1 to open a new office for an existing US entity, that would fall under the L1 category, which has initial 3-year term and then up to 7 for an L1A if you're coming over as a managed to open a new office. If you're coming over on the E-visa side to enter the US to open completely new operations as an investor, then Debrina, do you want to take that since you took E's earlier?
Yeah, so if you're planning to invest and get the E2 visa, usually my clients come on B1, which is the for business purposes. They open up the company, open up the bank accounts, basically do the initial setup, and then they go back, and then we apply for the E2. How long can you stay on the B1, B2? So generally speaking, they will give you 6 months status to stay here. Most of my clients don't take the whole 6 months. I usually don't recommend it because it's just too long, and it might raise red flags later on. But usually that's the vehicle they use to come and open up a brand new companies within the E2 context.
Okay, and what happens if the business fails?
Well, so initially with the E2, they give you it's for 2 years. They give you your status for 2 years. With the initial application, I always tell clients that USCIS or consulate, if you're doing it abroad, the US consulate, they sort of give you benefit of the doubt. So if you have if you have a good business plan, if everything is in order, if your documents are in order, you will get the visa. But after when you have to do the extension after 2 years or 5 years, depending on whether you got the the visa stamp for 5 years or your status in the United States, You have to apply it. I mean, you have to apply for an extension. And at that point, when you apply for an extension, then you submit all of your, records, taxes, payrolls, and you have to show that that business is actually, successful, and you're making profit. If you're not, then they're not gonna extend your visa. So in a sense, I feel like it's easier to get the initial one if all of your documents are in order. The business plan makes sense. And then, but at the time of extension, then that's where the heavy lifting would be for particularly for E2.
That's great. I think these are really good questions. You're welcome, Adam. I'm glad we could help you with that. So let's see here. Let me double check what I'm working on here. I have lost my form. So I think right now we're getting down. We still have about 10 minutes left. We have covered an amazing amount of information in a short period of time. And I'm sure some of the viewers have other questions, but let's see. There we go. This is an idea. We've heard some horror stories, a few, and I think that's always interesting. But what about success stories? Debrina, do you have a client who's just come over from Europe, and tell us about someone that that's just that this has worked for?
Yeah, fortunately, we have more success stories than horror stories, and that's the goal. I've had a client from Europe that came, and basically they're in the recycling field. So they established their first base in the East Coast. Basically, they are what they do is they're collecting used clothes and shoes and other merchandise, and then they ship it to Europe, and then they sell it as a second hand. So that's the business. They started with a very humble beginning, small investment, and ultimately now they cover East Coast, West Coast, and now they moved down to Texas as well. And it's a multi-million-dollar business right now. So here's a success story.
That's incredible, because I find it's amazing how many things that Americans give away, throw away, give to Goodwill, and we are really a society that very simply just put bags of things out on the street, and depending where you live, can be pretty nice things that are just out there for free. So that's a really interesting business model. I had never heard of that before.
Unique business in a sense, but very very successful business.
Amazing. Guy, do you have any success stories you want to talk about?
I, Sure. I mean, obviously, I'm no longer in private practice. I consider myself sort of a recovering lawyer now that I work for a financial institution. But one thing to talk about with Debrina and James and other attorneys that you might be working with is we actually had a client who very successful, sold his business, and then he actually came over here on an F1 student visa, right? And the beauty of that particular visa, as people like Debrina and James can tell you, is that you get up to 5 years without your days counting for the substantial presence test for U.S. income tax purposes, if you haven't already studied here, because it's sort of a lifetime exemption for those 5 years. So he came over, he sort of structured his assets appropriately, but at the end of the day, he's taking classes, maintaining all the requirements for his visa, but just enjoying his life, and it's such a cool thing to see when a guy's here, he's built his business, he's sold it, he's already kind of gone on with succession, and now he's just sort of enjoying the fruits of it sitting in the States. And also because of the way he came over, not necessarily an income tax resident for those 5 years that he's here. So I guess that's one that I always thought of, that, in terms of happy clients that are just excited about life.
Yeah, that's a great story. James?
Yeah, so about 1.5 years or 2 years ago, we worked with 2 F1 students who were here in the US completing their master's degree program. They completed it. They actually had a startup where they started a IT-based company that handled hospitality apps. And they were able to successfully grow that business from the two of them to about 25 individuals. And then they opened up operations abroad. And they were using their operations abroad to resource talent internationally as well. They ended up opening up 3 different branch offices in various countries. As their branch offices in these other countries started materializing into high-skilled workforce, we were actually able to then start bringing over some of their key executives from these branch offices to the US to further bolster the US operations. So we started doing a lot of L1 visas with them, and it's been quite rewarding to see a company grow from 2 foreign students who came here with a dream and really scale that into a multinational company now. So it's been great to see how that company has evolved over the past 2 or 3 years.
That's fantastic. Makes me think that we should have a webinar just on success stories and
Right,
feel
absolutely.
good. Not always about, how difficult it is, but what people have become when they have gone through, all of this and what is possible. I'd love to hear that. Well, I'd like to say that concludes our session today, and want to thank our speakers, Debrina Houston, James Garalas, and Guy Vascari for their invaluable insights. Thanks everyone for attending today's webinar. We hope these insights today will help you navigate your U.S. immigration and tax journey successfully. And if you have any further questions, feel free to reach out to our speakers. And we'll have a QR code page with some contact information shared with you, or visit the EACC Texas, New York, and Carolinas, who are your official EEN partners in the United States. We all have websites with lots of resources, and we're here for that. And right now, I'm delighted to introduce Alberto Valenzano, team leader at the European Commission. Alberto will offer some final remarks on behalf of the EU Commission, and which is a very key partner in this series of webinars. They and the United States EEN partners have just had a delightful time bringing these to you, and we have one more in November coming up. So, Alberto, turn it over to you.
Thank you, Erin. Well, you actually said it all already. I also wanted to thank you for moderating today, and for being with us, and for guiding our speakers into this very insightful discussion on U.S. immigration. So also from my side, thank you to Debrina, James, and Guy for their expert advice. I believe that you have shown today how complex the system is, but this should not come as a surprise to European SMEs, because our system is very complex, given that it very much depends still on the national level. I don't think this comes as a surprise, but I think the solution you have given could be summarized into prepare early and get expert advice to get your information right. Make sure not to make mistakes, basically. So that's why we have this webinar today, and also why we have our local EN partners in the US that can support. And also, if you're a European SME and you're already in contact with the EN partners in Europe, your EN partners in Europe can connect with our partners in the US and facilitate your access to this wonderful market, which I know can be very attractive, but requires quite a lot of preparation in advance. So said that, indeed, Erin, you already mentioned that there will be a next webinar. So it's going to be on the 21st of November, and it's going to be about employment and human resources when entering the US market. So I invite everybody to reconnect on our page and follow this new webinar in a few weeks. And you find all of them on the Entrepreneur Matter website, on our YouTube page, and they're always the same format. So they're very quick, but very insightful, 1 hour, and you'll get all information you need about the topic of the discussion of the day. And with this, I think I will conclude, and thank also Thomas and the colleagues in ISMEA and in the Commission who always work behind the scenes. You don't see them during the webinar, but they are there, and they support very much. So thank you, everybody, and I hope to see many of you in a few weeks in the next webinar.
Thank you.
Thank you very much.
Thank you.
Okay.
Thank
Bye,
you all.
everyone.
Take care.
Have a
Bye.
great one. Thank you, guys.
Great job. Great.
Bye
Thank
bye.
you all.
Thank you.
Bye-bye.